This is David Olshan of Nevada Legal Services. It's Saturday, November 26th, 2022, and this is a legal update. We want to talk about student loans and how the Department of Education and Justice are combining efforts to allow a local attorney for the Department of Justice to discharge student loans in a Chapter 7 bankruptcy. It gives discretion to the Department of Justice and their local attorney to decide whether somebody qualifies, and it's going to make it much easier for you to discharge your student loans in a Chapter 7 bankruptcy. First of all, it's very difficult right now to discharge student loans in a Chapter 7 bankruptcy. You need these three standards in the Bruner test, Bruner versus New York Higher Education Services. You can't maintain your minimal standard of living and pay your student loan. Circumstances that you're under are likely to persist for a significant portion of a loan repayment in the future, and you've made a good faith effort to repay. A bankruptcy judge will trip you up on one or all of those standards, and that's why it's difficult to discharge in a Chapter 7. There's an easier test known as a totality of circumstances, where you look at the debtor's past, present, and future income and decide whether they're going to be able to pay the student loan. That's a little bit easier, but it's also difficult if a judge doesn't want to discharge your student loans. So what the Department of Education and Justice have done with this new approach is to allow the local attorney to assess the circumstances of the debtor. You're going to look at your present circumstances, and you're going to use IRS expenses to determine if you have enough income after expenses to pay your student loans. And there's flexibility in these standards, so if you have to pay extra medical costs or take care of a disabled dependent, the Department of Justice will consider that. Then we look at future circumstances and these presumptions, which makes it very easy to discharge a student loan. If you're 65 or older, that means that the present circumstances are likely to persist, and you are approved to discharge your student loan. Also, if you've been unemployed for 5 out of the last 10 years, if you failed to earn a degree, or if your loan has been in payment status for at least 10 years, there's a presumption that these conditions that you're in now, where you can't pay the student loan, will continue in the future. And these presumptions are very helpful. You don't have to prove them now, you just have these presumptions. Of course, these presumptions may be rebutted, and again, the discretion is left to the Department of Justice. When we look at good faith, we're looking at whether you've made a payment, whether you've applied for a deferment or an income-based repayment plan, if you consolidated your student loans, or even responded to outreach from a servicer or collector. That is going to be a good faith effort to try to repay your debt. So by categorizing these and giving examples of when you have good faith or when conditions will exist in the future is so helpful, and it does help the lawyer for the Department of Justice decide whether they will stipulate to discharge the student loans from the Department of Education. So one thing to keep in mind is your loans have to be with the Department of Education and not a private student loan lender or somebody who's not with the Department of Education. But if you do qualify, you fill out an attestation, you file it into your case. The Department of Justice, their lawyer, will look at it and decide whether they can stipulate to discharge the student loan debt. The link is below for this information, and please visit it. We are Nevada Legal Services. If you want help with your student loan, we can help you file a bankruptcy and discharge those student loans. So fill out an online intake at nevadalegalservices.org, and we may be able to help. Thank you.